Yesterday, the Supreme Court of the United States did something that had not been done in 91 years. Something that survived the New Deal, survived World War II, survived the Cold War, survived a dozen presidents from both parties who each, at various points, might have wanted exactly this kind of power and never got it. In a 6-3 ruling, the court tore it down in a single morning. We are talking about Trump versus Slaughter, and if that name means nothing to you yet, by the end of this video, it is going to mean everything, because this ruling just handed the President of the United States, this one and everyone after him, direct, personal, unrestrained control over roughly 24 federal agencies that were built, by design, to operate independently of the White House. The Federal Trade Commission, the Federal Energy Regulatory Commission, the Consumer Product Safety Commission, the Nuclear Regulatory Commission, agencies that regulate the food you eat, the products you buy, the power that runs your home, the safety standards that protect your children, all of it, suddenly answerable directly and personally to one office. This is not a headline you are going to see explained clearly on the evening news, because explaining it clearly means admitting how enormous it actually is. So let's do what they won't. Let's go through this ruling piece by piece, and by the end you are going to understand exactly how much changed in this country yesterday and why both the people celebrating it and the people terrified by it are, for once, looking at the same set of facts correctly. If you want the version of the news that does not flinch from telling you when something this size actually happens, subscribe right now. This channel exists because these moments get buried fast, and somebody has to keep them visible. Let's get into it. To understand what just fell, you have to understand what stood for 91 years in its place. Back in 1935, Franklin Delano Roosevelt tried to fire a member of the Federal Trade Commission, not for any wrongdoing, not for incompetence. He fired him because the man, William Humphrey, kept disagreeing with FDR's economic policy, and Roosevelt simply wanted him gone. Humphrey sued, and the Supreme Court, unanimously, every single justice, ruled against Roosevelt. The case became known as Humphrey's Executor, and the principle it established became one of the load-bearing walls of the modern American government. The principle was simple. Congress, when it created certain agencies meant to regulate markets, enforce consumer protections, oversee nuclear safety, manage independent economic functions, had the constitutional authority to insulate the people running those agencies from being fired by the president on a political whim. Not insulate them completely. The president could still remove them for cause, inefficiency, neglect of duty, actual malfeasance. But not because the president didn't like their politics, not because they made a decision the White House disagreed with. The whole point was to create a category of government function that operated on expertise and law rather than on the electoral interests of whoever currently held the Oval Office. For 91 years, that wall held. Every president, Republican and Democrat, operated within it. Nixon worked within it. Reagan worked within it. Both Bushes, Clinton, Obama, Biden, every single one of them governed an executive branch that included agencies they could not simply purge of officials who disagreed with them. That changed yesterday. The case in front of the court involved Rebecca Slaughter, a Democratic-appointed commissioner at the Federal Trade Commission. In March of last year, President Trump fired her, not for cause, not for any documented failure in her duties. He fired her because he wanted FTC commissioners who would not push back against his agenda. Slaughter sued, citing the 91-year-old precedent that said exactly this kind of firing was illegal. A federal district judge agreed with her and ordered her reinstated. An appeals court declined to pause that ruling. So the administration went to the Supreme Court. And the Supreme Court, in a 6-3 decision, sided with the president and did something far more consequential than simply ruling on Slaughter's individual case. It explicitly overruled Humphrey's executor, not narrowed it, not distinguished it, overruled it. Chief Justice John Roberts wrote the majority opinion, and the reasoning he used deserves careful attention, because it tells you precisely how this is going to apply far beyond the FTC. Roberts argued that the 1935 decision had been built on what he called a highly circumscribed and almost fictional view of what agencies like the FTC actually do. In 1935, the court had described the FTC as an entity that exercised no real executive power, that its functions were, in the language of that era, quasi-judicial and quasi-legislative rather than truly executive in nature. Roberts looked at the modern FTCE, an agency that investigates companies, brings enforcement actions, issues real regulatory consequences with real economic teeth, and concluded that description from 1935 was simply no longer accurate if it had ever been. In his words, the FTC unquestionably exercises executive power and must therefore be controlled by the president. And if the FTC exercises executive power, the logic does not stop there. It extends to every other agency built on the same structural model. That is the part that should stop you. This was not a ruling confined to one woman's employment dispute. It was a ruling that dismantled the legal foundation underneath the entire category of independent federal agencies. Justice Sotomayor's dissent put the scale of this in terms that are hard to misread. She wrote that the ruling, in her words, reshapes our government. She specifically named the agencies now exposed: the Federal Energy Regulatory Commission, which oversees the nation's energy infrastructure and electricity markets; the Consumer Product Safety Commission, which recalls dangerous products and sets safety standards for everything from children's toys to household appliances; the Nuclear Regulatory Commission, which oversees the safety of nuclear power plants across the country; the Merit Systems Protection Board, which exists specifically to protect federal employees from being fired for political reasons. Read that list again slowly. These are not symbolic bodies. These are agencies whose decisions determine whether a nuclear plant passes a safety inspection, whether a toy that could choke a toddler gets pulled from shelves, whether the electrical grid serving your home is regulated by people focused on engineering and safety rather than by people worried about staying in the president's good graces. Sotomayor's argument is not an abstract separation of powers concern. It is a concrete warning about what happens when the people making technical, expert-driven safety and economic decisions know that disagreeing with the president on any issue at any time could end their career instantly and without cause. That is not regulatory independence. That is regulatory obedience. The theory underlying the majority's decision has a name. Legal scholars call it the unitary executive theory, the idea that the Constitution gives the president complete, total control over the entire executive branch, with no exceptions carved out by Congress for independence or insulation of any kind. It has been a fringe legal theory for decades, championed by a small number of conservative legal scholars who argued that Humphrey's Executor was wrongly decided from the moment it was issued. Yesterday, that fringe theory became the law of the land by a vote of 6 justices to 3. Here's what makes this moment genuinely strange and worth sitting with for a second, because it complicates the easy narrative in both directions. The same week the court handed Trump this enormous victory over independent agencies, it also ruled against him by a narrower 5-4 margin in a related case involving Federal Reserve Governor Lisa Cook. Trump had tried to use the same logic to remove Cook from the Fed, citing unproven allegations of mortgage fraud that Cook has denied and that she has characterized as a pretext for removing her over disagreements about interest rate policy. The court said no. Chief Justice Roberts, joined by the 3 liberal justices and, notably, Justice Brett Kavanaugh, drew a specific line around the Federal Reserve. The reasoning is that the Fed occupies a unique constitutional position, a nonpartisan institution managing monetary policy for the entire global economy, one whose independence from short-term political pressure is treated as foundational to its credibility in financial markets around the world. No president since the Fed's founding in 1913 had attempted what Trump tried with Cook. The court, even with its newly expanded unitary executive theory, was not willing to extend that theory all the way to the central banks. So what you have as of this week is a Supreme Court that drew a very specific, very narrow exception around exactly one institution, the Federal Reserve, while clearing the path for the president to take direct control over roughly 24 other agencies that touch nearly every corner of American economic and regulatory life. That is not a coincidence. That is the court signaling precisely where it is willing to stop, and the line it drew tells you something important. The justices understood that gutting the Fed's independence specifically would have triggered consequences serious enough for markets, for the dollar, for the entire architecture of the global financial system, that even this majority was not willing to go there. Everything else apparently was fair game. Let's talk about what this actually means in practice, because the theoretical separation of powers argument can feel distant until you see it land on something specific. Consider the Consumer Product Safety Commission. For decades, that agency has operated on a model where commissioners, once confirmed by the Senate, serve fixed terms and make decisions based on engineering data, injury statistics, and safety science, regardless of which party controls the White House. Under the new framework, every single one of those commissioners now knows that a decision the president dislikes, blocking a product from a politically connected company, for instance, or issuing a recall that creates bad press for an administration, could result in immediate termination. Not because the commissioner did anything wrong, because the president wanted someone more compliant in that seat. Consider the Nuclear Regulatory Commission. This is the body responsible for licensing and overseeing every nuclear power plant in the United States. Its independence from political pressure has historically been treated as a near-sacred principle, for the obvious reason that nuclear safety decisions should never be influenced by electoral calculations or campaign donor relationships. Under this ruling, that insulation is gone. The commissioners overseeing the safety of facilities that, if mismanaged, could produce a catastrophe affecting millions of people, now serve at the pleasure of whoever occupies the Oval Office. Consider the Merit Systems Protection Board, the single agency that exists specifically to protect ordinary federal employees from being fired for political reasons. The body designed to be the last line of defense against a politicized civil service can now itself be staffed entirely with appointees who will not enforce that protection against a president who wants it gone. The watchdog has been placed under the direct control of the entity it was created to watch. This is the practical reality underneath the legal abstraction. It is not about whether you like this particular president or trust his judgment on regulatory matters. It is about whether any future president of either party should have the power to fire, at will, the people responsible for nuclear safety, product safety, energy markets, and the protection of federal workers, simply because those people made a decision the president did not like. The political reaction split exactly along the lines you would expect, but the substance underneath the reaction reveals something larger about where American government is heading. Supporters of the ruling chair, and there are serious legal scholars among them, not just political operatives, argue that this is a correction of a long-standing constitutional anomaly. Their position is that the Constitution vests the executive power in the president. Full stop, with no asterisks for agencies Congress decides it wants to wall off. Under this view, Humphrey's executor was always an awkward compromise that never had solid constitutional footing, and the unitary executive theory simply restores the framework the founders actually intended: full presidential accountability for the entire executive branch, with voters able to hold one person responsible for everything that happens inside it. That is a real argument made by serious people, and it deserves to be represented honestly rather than dismissed as pure power grabbing. There is something coherent about the idea that if voters are going to hold a president accountable for the performance of the federal government, the president should actually have control over that government. But the counter-argument the one Sotomayor and the dissenting justices are making is just as serious. It says that some functions of government were deliberately designed by Congress to be insulated from electoral politics precisely because subjecting them to electoral politics produces worse outcomes: corrupted safety decisions, regulatory capture by whoever has the president's ear, agencies that bend technical judgments to fit political convenience rather than evidence. The Federal Reserve exception the court carved out this same week is itself an admission that this concern is legitimate. The court simply decided it only mattered enough to protect in one specific case. What happens now in the weeks and months ahead is going to be a rapid restructuring of how dozens of federal agencies actually function. Expect personnel turnover across every agency this ruling touches. Commissioners and board members who were appointed under previous administrations and who do not align with the current White House's priorities are now legally vulnerable to removal in a way they were not 1 week ago. Expect new appointees who understand explicitly that their continued employment depends on staying aligned with presidential preferences rather than on the independent judgment Congress originally intended them to exercise. Expect litigation to continue, because while Humphrey's executor itself is gone, the precise boundaries of this new framework are not yet fully drawn. Which agencies count as exercising executive power under Roberts's reasoning and which might still retain some sliver of insulation will be fought out case by case in the lower courts over the coming years. And expect this fight to become a central feature of presidential elections going forward, because the stakes of who occupies the Oval Office just expanded dramatically. A presidential election is no longer simply a choice about who runs the executive branch in the traditional sense. It is now, more than at any point in nearly a century, a choice about who personally controls nuclear safety oversight, product safety enforcement, energy market regulation, and the protections meant to shield career civil servants from political retaliation. There is a thread connecting this ruling to the others the court has issued this term, and it is worth naming directly before we close. This week alone, alongside Trump versus Slaughter, the court ruled that federal courts cannot review the executive branch's termination of humanitarian protections for over 1 million people. It ruled that asylum seekers can be physically blocked from ever setting foot on American soil to make their case. It gutted the last meaningful protections of the Voting Rights Act earlier this term. Each of these rulings, examined individually, can be defended on its own technical legal merits, and serious legal minds disagree in good faith about each one. But examined together, a pattern becomes difficult to ignore. Across immigration, across regulatory agencies, across voting rights, this court has consistently ruled in the direction of expanding executive power and narrowing the mechanisms, judicial, congressional, or institutional, that have historically constrained it. Whether you view that pattern as a long overdue correction of decades of bureaucratic overreach, or as a dangerous concentration of unchecked power in a single office, depends on your political starting point. But the pattern itself is not a matter of opinion. It is sitting in the official record of this term, case after case, ruling after ruling. The Constitution's framers built a system on the explicit premise that no single person should hold unchecked power over the machinery of government, because power without accountability produces abuse, not as a possibility, but as a near certainty over a long enough timeline. The independent agency structure that fell yesterday was one of the checks built specifically to prevent that outcome in the regulatory sphere. It survived 91 years and 19 presidents. It did not survive this court. You made it to the end of this one, and that matters because most people are not going to understand the size of what happened yesterday until it shows up somewhere in their own life. A safety recall that does not happen. A regulator who does not push back. A decision that bends toward politics instead of evidence. By then, the ruling that made it possible will already be old news. Subscribe so you do not miss what this court does next. There are still cases pending before the term fully closes, including birthright citizenship, and the implications of this week alone are not finished landing. Share this with someone who needs to understand what just changed. And leave a comment. Which of these newly exposed agencies worries you most? Product safety, nuclear oversight, energy regulation, or federal employee protections? Let's talk about it. I will see you in the next one.